Appiah Kubi. Mo and I see and start here Jumebia. It's a good show. It's a show walk up into your relax. Share. When him the eba. Miss none of you. Accra High Court dismisses and the Appiah Kubi's application to withdraw legal services for Chairman Wontumi in Samra Boy case. Yes, see, and in some way, no, mudo no, mon share da enya but oh say, they be am catch a Ghana for more fee near bruchery. Asamoba, look for the right source and follow the document, the information. Obetia say, the Martin and say, Appiah Kubi say, or onye Chairman Wontumi lawyer be last week Friday, me catch them say Chairman Wontumi lawyer kase onye Chairman Wontumi lawyer be ma. It's got nothing to do with the court. No. It is an agreement between the client and the attorney or the lawyer. That's it. The court has nothing to do with Chairman Wontumi lawyer, especially when the case has been exhausted. The court has nothing to do with it. Say, and the Enra ye share a year for a Tunisia for Abra Omubo World Cup no. Tunisia for Apamu Omu coach and then it's got nothing to do with FIFA. Tunisia, any coach, you know, agreement that he can be fired at any time. So it does not affect the FIFA tournament. It's the same as in the courtroom, especially to say, yeah, ball, yeah, finals, and now yeah, a tournament. Now your ball game with FIFA just a 90 minutes plus extra time and now added time. Now your ball ni nyine. Now your ball added time no so account. Ye game na afei wa ba be catch FIFA say. Na nka also ye changes be. Ye ma 5 options also ye changes 5 ni nyina ba wo ye 40. Oh protect say identity. But that decision was up to you. It is at your mercy. You make those decisions. So obe change 4, obe change 5. FIFA say amount 5 slots. Make those changes. It will decide so use 1 and now 4 and now 5. It is at your own what advantage or disadvantage. So that got nothing to do with FIFA. And this is what is happening right now with this Appiah Kubi and Chairman Wontumi issue. No, it is simple as that. And the major idea or plan behind this is that they want to delay the case. Omnim say court no any the judiciary any lawyers no mobile call break, and they want to find ways to delay Chairman Wontumi judgment na no. But something happened in court today. Something happened that most media houses did not take their time to explain to Ghana for. And many would say ayesade we ama mo amu Kumasi asante for mu di MPP china ma bon na mu nsua de na mo sori a mu mubi mu nkura sese am de ti Wontumi no mo da mo mbeda da mo ana mo behwe no na mo mpanifo nyina ya che o magum e won kran Chairman Wontumi okodem a o medem Kumasi o bebi apoda e de betum eni sa mo betena mo mubi betena Kumasi mo mubi betena santimemu say ya MPP for ma nipa bi agimi mu a mo ni bete no na mo ankasa no ye de mu kotum obi antan obia but matena wa ma eye party no nokre onka nkyerem e na mo so mu musansa mo so na matemoto bini na modi na mudi party na chi nti mo dodo no omo musa mo asai mo adwene wo fom na ma medwedwe bibi mu nkyerem team stay with me. And Appiah Kubi say or court akoka kire judge ne say ono Appiah Kubi onye Chairman Wontumi lawyer biem. That's fine. Now okopie court dey ne see judge no etie Appiah Kubi asem. Ena sa particular asem we Appiah Kubi di buy no judge no rule was so. Now you see court no dismiss Appiah Kubi asem or the buy just say asem or the buy nyanse nim eningina so nti court anje antum. Appiah Kubi call court ko ka kire judge ne say me ne me client ne enye adwuma biem. Ena judge ne say asem we dey say emfa court ho. Say o client today another lawyer beba or the dear beba o client asem me dey what I know and say the woman nim no eno na me di adwuma nti ono client akuo so client akofa o girlfriend o so ono client akofa o big girlfriend ya bobi I don't it's got nothing to do with the court. Now they see o court ni judge no rule and that ruling me be kan akere me wi na ma kere bibi o ruling nim Remember, as some way a Samurai Boy case win on the 3rd of July and a judge in the judgment. Remember, Oba on the 3rd of June no, and Okache say on the 3rd of July no, and yes, or the judgment beba. So technically 1 month. All right. Now, so technically, as some na a work court and ye dear we ya can we evidence that judge in no and then already actual no judgment. So won't be for and on the for. It is what is before the judge. It is not about the lawyers. What am I say? Now, judge, you know, or dismiss Appiah Kubi as someone no. Mami ready the oka yankasa. Ewo sa the esi o court in there. Ni engine so. Send a bear out to a mama kwasi bintina Wontumi. Kwasi bintina Kesbin. Kwasi bintina radio phone bi so nka nkyere wo say. Oti asase radio. Kwasi bintina Metro TV nka say oye Paul Ademochire. Na on that because adada ne mama mudodo no at the end of the day kwasi campaign to support Ademochire to make a 2 say Kumasi International Airport international Kumasi Airport international airport san kwasi adada we na budi akire no mudodo amugu asantime mu no munsua de nkenkan emma mo kwan musansem no ena ma kwasi campaign to support Ademochire to be ba Kumasi ebetwe 2 ase de elikosi Kumasi Airport say international airport no because mudodo no mo agimi mo musansem. Yenra court. Oja we muna. Ntiminya den. Go we dey give you umejuma for off. This is what happened in court today. Mami biem na mjujum na Ghana fo hu. Ansa na kwase be waka say, "Sade we mo amoditi Wontumi radio ne Kesbin FM ne MPP4 radios no. Ana mo ntintam we na mo fa nkire nkofo no mo ankokan." Bagitum ye wie no, enso me sanye modwuma mamo. Mo gimi de. Sankrata we ye wie court anama ko de be mamo na ma be kan akire Ghana for the judge ne kan ye enu ano no na afei mo ken kan bro for na madwudwam me san wini power and protect NDC 42 years na me san nyamodwuma mo gimi NPP communicators no modwuma ne san Wontumi ken kan jejirem. This is simple. Why are you people making it so complicated? Momianko kan dey see court in there. Now in the Superior Court of Judicature, in the High Court of Justice, Criminal Court 4, held in Accra on Monday, the 15th day of June 2026, before Her Ladyship Audrey Kosuvi Tay, Justice of the High Court. Now, case number CR004/2026, time 9:02 a.m. And Nanopa and Sebio Omo Echo Court on this matter, certified true copy. Now, the Republic versus Bernard Enchubo Siakon, Kwame Entry. Nipa 9 nipa miensa ne charge o ba ko adwane. Samurai Boy case no. Bernard Enchubo Siakon chairman Wontumi ye charge no. Kwame Entry at large what the waka buying boom woko. Kwame Entry ne hu no. Ena aya akonta mining company ye chairman Wontumi dia. Mo MPP for mu ni madwuma me san be ye madwuma na kam tell say amenya moden. Now mama ndwom accused persons A1 presents and represents A3. Now, Mamenkai ruling into Appiah Kubi court the judge ruling ni the jina so or the conclude assembly so dismiss Appiah Kubi some person chairman Wontumi lawyer no judge say ni jina so fako. Mamenkin kana mjujum. Well, simple. Ochina monkin kana already so NPP for obejimi. Now, ruling before the court is a motion on notice for leave to withdraw legal services for first and third accused persons. You see, before the court, no, enkrata that way a free Appiah Kubi no, enkrata a lawyer or representative chairman Wontumi any akonta mining. Kwame Entry we done into only lawyer. In Appiah Kubi there, or say or withdraw the services. Onye Wontumi lawyer biem and onya akonta mining lawyer biem Kwame Entry there we done into any baby Kwame Entry wo enti yaka say nyina say Kwame Entry dwane Kwame Entry what the one buying boom wuram ye wu baby odena Kwame Entry is at large what you now Kwame Entry mon kan one self no, but now, I have also listened to learned counsel on both sides on objection raised. I have also considered the applicable law. Now, it is the considered opinion of this court that the instant application is a surplusage. It's a surplusage in the sense that there is no procedural requirement for a lawyer in a criminal matter to file an appearance. In much the same way, there is no such procedural requirement either under the criminal and other. Kevin, where the one change my antiasia, a buofun, so as many do water, Minam. Now, Bamentoaswa. Utwaswa, Quasiafo, Abanum, where the Kevin and Jeremiah antiasia, a buofun, natural medimatum. Now, Utwaswa will say offenses. Act 1960 at 30 or by judicial precedent that I had come across that a lawyer who has decided to cease to act for his client in a criminal matter must seek the leave of the court to so withdraw. Judge say, "Can tell that the no hune de e ya de bi kropa etwa na kumem etwa ne yam sebio e ya sembia eye na adwi mu sekrene se enne asem wo court na lawyer onim mra onim se sebio court mratie na sa lawyer ne ono ne client enya problem na lawyer no na adwene ye ne se obetumi aba court na obeka kire court se nipa na meye ne lawyer no meni na gya adwuma ye o se ohu ne se engineer so bie ni so in fact wohwe Ghana mremu a we ya de a ewosanka eye den Appiah Kubi a ono de sa moshi we ba na ete ase se engineer so bie ni se ewosa oba court kura be krame se me ne me client eye chema Wontumi ye nya adwuma biem o se asem no kura mpo no etwa ne sunum ama na num aye no nwono o kan a o se asem na eye Appiah Kubi de abeto se oba court abeka kire me judge se chema Wontumi high no na ono judge no oni ho chema Wontumi ne ene ne keka sika asem so obetua le ka a day no per hour no na oni wo no se nde Appiah Kubi ni chema Wontumi gya adwuma ya aden na waba court abekire mu se na me ni we na ye adwuma na ye den ye nya adwuma bi wo se ene de on de ohun ne se eya asem ya eye bosremuka eya asem ya eni nyina so eya asem ya sebio I to say Appiah Kubi on shada nim de okeka na ama ono judge kwa nenum ato eno na kaza supplicage ama nenum ato ye dwudwam opa akobie wo de na wo so kotukyere mu ho se me mabon wo na wo PhD ko me ni PhD me go school kurada enti wo na wako school wiase yira ko na ko kyerɛkyerɛ Facebook ye nyisika aboa paragraph 3 ye dwudwam even though the respondent has raised other grounds of objection, the objection is sustainable on only one main ground, which is the application by counsel for leave to withdraw from criminal proceedings is not a function of any rule of procedure nor of settled case law jurisprudence. Kai aba osi ewom se asema eye Appiah Kubi de bae no sebio omo a eye attorney general mokra so asore etia se asem ne nyina so no o se ono ngasa judge no otena asem no hwa asem na court nsensem mu ne court nyina so no ohu asem bia krampo a onkotwa ho nam emfa metoto ade a Appiah Kubi ekire o se hwede pompo ekire wa motiom because eba court mremu a ohu eye asem ana emra bi kra ontumi nkotwa ho emfa mbeka asem wankasa wempo de ene ne sekakra o se o check a jurisprudence any brofo kese o use ye no o se the Appiah Kubi ye no I said the pompo e kire wa botuom na on seda ni asem on seda ntumi nko eye court mrem enhwehwe nkrata mu ehun posa asem bia ba obetumi gina ka say okay ye twa asem mi ho kakra ene edidi asem bi o se onhu bi aboa o dia se mi dwudwam Kobie wo de Facebook yenji ska kwasiato ruling na making ka kire wo no wa ma ska ade acha wo de kwasia se bedidi otu vu atem komenhia ne kire mu kire wo paragraph 4 tieniye pa judge ni judgment ni the instant application is alien. Judge ne say, eye krata na Appiah Kubi di aba no. Eye tete extraterrestrial spirits. Honhom bone honhom a ebi ni asase so a de bia na excite omo tete from aliens emfiasas or say the application is alien or say in samampom na be hun krata we atro we bi or say the instant application is alien and not a procedural requirement in criminal proceedings or say krata Appiah Kubi di ba say oni chairman Wontumi nye adwuma biem ono oyejaja omu nyina tekod o say sa krata na otro de beto wo no eye bosremuka sebio eye honhom nsem a sebio che ebi kura ni asase so eye alien ye ka say bibi ye alien a ye nhye dan hwehwe muhu ni gina bie eni gina so ninjina bia ni ho yentumi ntwa asem bi mfa nkasa asem no if you say nipa ninjina so and if an alien you cannot at the end of the day prove it. I say asem no aya ni nyenyan it's enunciating and word no you see or say it is alien and not a procedural requirement in criminal proceedings or say eba kro no ho nsam keka enchirechire mu ne court ho den ensamdia o se saa asam na eye Appiah Kubi ka no I just said ye pompo e kire wa motuom enjina so enhyeda ni ho so it is antaso wa fe wo se brantie de o ya de o aboa me ya de kwase ampe we abedi matanso de o tu voatem into a UFO extraterrestrial spirit. Yes. Judge Nukra is shocked. She is amazingly amazed, conspicuously convinced that this despicable application is alienated to the alien level of UFOs. Now, young paragraph 4, or see, counsel herein does not need leave of this court to withdraw as counsel. Or see, or see Appiah Kubi. On here court permission say on the chairman Wontumi beja adwuma court de won ne ko sign contract na mini ho na mini ha court ni ho chief justice ni ho judicial service ni ho enti embemu krampo say wo be so na papa woto aba woto powder abegina say me chairman Wontumi nya adwuma biem no o see emra kura no bia ni wa a kire say o sank otu sa na mo no yanko anim. This is an issue between himself and his client. That is, in this case, the first and third accused persons. Or see, sa same way Appiah Kubi dia begina quarter, or yet say pompo kire wa motuom ogu o samra ne ho je ne ho samra ne no. Or see, sa same way ono de clearly no enya sama ye de ba court. Or say eye between chairman Wontumi akonta mining any Appiah Kubi omonko fie no omonko solve. Judge ruling ni ende wie onso man kinkan we ankyere mo kwasia 40 Wontumi ne nkwasia Kesbi ne omugimi FM ekekan kwasia sam munti asam no enje nkrantan kinkan. This application is an alien application. Alien application. It's a pure alien application. Now, Okudeni no say if he chooses by his personal decisions to abandon his client, brofuna judge natural no. Or say if Appiah Kubi chooses, if he chooses, one can say if the court chooses, one can say if I the judge or the prosecution, or say if he chooses by his personal decision on one can say pem. So ye na adwene say so o siri trimu pi na ono ani pem o ye na adwene say obeto eye chairman Wontumi ato atwene e wo kwan so abra make sure eye judgment o say sa ade no at this stage no it will not affect the timetable of the proceedings. O say sa Appiah Kubi ankasa free ni pem oboni na adwene mu pi o hye no ho bo na oya na adwene se baby omodu no obeto chairman Wontumi ato atwene na one na gya adwuma dia ose eno no ne court de enka no court na aka no court skirt ose ne court ne de ebo adwuma ni nyina ne sen ye nyina ye twen judgment on the 3rd of July. Enti inkura Appiah Kubi ene chairman Wontumi ene akontaman na ebo abonte no se enka court dwuma dia yedi. In fact, the court does not recognize it. Me catch them last week. Yanko enim metro baby e wana enkini wom. Say MPP for you see dodo mu di MPP chi no mo jimi. MPP for no mo nkran na omba ni okumasi a na MPP kumasi for no twa ho hia. Ebini frinkran bo ebini frinkran ne rekete ginim omo musansam. Enti dia na nkranfo no ye ne se MPP nkranfo no eye ba omiane ne nkofo no omo ba kumase no mo benne wo kumase a no be jajandam na to na ye ne eye MPP for the wasantibem no ne start group ebini frinkran bo ebini frinkran bo ebini frinkran bo no mo so ebini frinkran ba omo musansam wan bini nie eduane be no di ye no di gobe ye nim ebini frinkran bo ebini frinkran ye mbusansam enwan se ebini frinkran ba ni egu ho ni ejimi MPP nti mo jimi o. Now mame ko be ni na mjidwa de akanim ejuma ne ye o hwa akọ hwe o hwe na wadi kuma eye simple we menshel miam show miam sika
se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho baye den eman se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho baye den eman se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho baye den eman se wani kuma kokoda se wo hwe na wani nkum so a
ebini frinkran bo ebini frinkran ne abenne no mokọ ne edi ho agora de hia na se ebini aba ebini frinkran bo ebini frinkran amini we influence na mensa kakra gigiri na kete fora gigiri ebini frinkran bo ebini frinkran bo ebini frinkran ni atwe ebini frinkran bo enkranfo na benne enkranfo MPP fo na benne okumase ene egu ho wadwa ko bia wo de Facebook ye jiska abuofunu mama dwodwam now over paragraph 5 ebini frinkran mo de mo tatra na monya o Appiah Kubi o de cheba o di kosan contract na Ghana ba o na abuofunu the state did not employ you Appiah Kubi na yapamo a o ba be ka kire state no e de nkwasa keka no ebini frinkran now mamen kind de wase no e ho na ink no wo ye wi a say ye nyankase show about 11 o Ghana nkwasa journalist for Wontumi kan kan kire mo motete wona jimi paragraph 5 Judge in the ruling or say the application is not competent before the court. Or say application about me. So competent or say the application is not competent before the court. The judge in the park change and say Sakratana Appiah Kubi di buy no sebio where the nanosisumina so ayan kwasiansam e sheda ninjina so enya sama nyansa wo ma wo se nipa tena ho epopo mu bensem pensemu edwini mpo se obedi hu dwuma o say the application is not competent application no nyansa nim eninjina so emfaso ni so entumi say court the time nipa onim de onfa saa ade we emba enti judge no she was being diplomatic about her statement, being politically correct and legally reasonable. She was rationally dissecting the foolishness of Appiah Kubi in a more matured, deliberate, and fantastic way. It uses said the application is not competent before the court. It was say some na Appiah Kubi dia bano nyanse nim but okani Christom yanko enim na menjudwom okunen was say assuming without admitting that the application were even competent before this court, the court has taken notice that the lawyer seeking to withdraw has not directed service on his own client to enable them appropriately respond. Or say, young fan in say, or judge is okay. What ye a woman says some of the banyan, but young fan is say, ye per se, the other banumpo, yabejatum. Appiah Kubi cramponumpo and serve chairman Wontumi officially. And can't say, Minue J. Jumaye. Just Appiah Kubi no, and Kwasiadi buga nkurasem. Court and say, ah. O de young fan say, Sankwa just say we ajatum. Na sa ne clients na ono enti oba court hano. Sa ne clients krono crampono Wontumi officially and can say, Mo Minue J. Jumaye. In his application, he could not states that officially he has at the end of the day withdrawn from being the lawyer of these two clients. So judge this now one can say what about sign contract when no client didn't come munim dia mobeje afei mujja mo come on break it down yenya o quarter be disturb fa so be no so e dia nsem hunu no the application is not bawomia. So the judge is saying the application is not Baumia, it is not competent. The application from Appiah Kubi, no, it is Baumia, it is not competent. Into say, oh dear, young fan say, Yemfa obuo ema Appiah Kubi. Ni anka say okay, Appiah Kubi. O de other body ajatum. Na ye pese ebusa wo. Sa eye enkofo na ugina o manemu wo court ha no. A chairman Wontumi na kontamine no. Officially mpo waka chom so ne omunye adwuma biom. Yansa bi anim osingina so nim ebini frinkan bo ebini frinkan mo de munimal se MPP fo abani agu Kumase na MPP fo a mo Kumase na mugu ho ebini frinkan ba na mo che ne se force oh we de ye we first selection ebini na mo che ne first selection mumbu sansam ebini we firi he wan dia odi aduane ben he na okodidi munnim de munimal se ebini frinkan. Ya kind of one client, yes, yeah. Jema won't be jelly now, baby. Mahamba, Ibrahim, a Jimmy for one king. I mentioned we are inking woman. Now, over paragraph 6. Pay attention. Let me change this and put you on paragraph 6. Hono, Yashada, I highlighted, maybe Chawa debut ho. Paragraph 6. Let me read paragraph 6. And when I be say, "Sa case na muhu simple sa no." MP for you so be Jimmy. Now let me read the paragraph 6. Any. I mention idea judge in the tro ho. I mention tro. O see. O see consequently. And yet consequently. Consequently. And consequences, the consequence, yanka consequences. Me mama chebro for kakra wa ha Jimmy for no. It is your choice. Yanka, it is your choice. Jimmy. We don't have any choice. We are waiting and we will see what they will say. Yanka no a choice and your choice. Let them do what they want to do. It is their own choice. A beautiful choice. One choice. And your consequence, a consequence. Consequently, the O is silent. It should drop in your throat. Consequently, and yet consequently. I wonder. We don't know the consequences. We are here. There are consequences. There are consequences. It is their own. They will face the consequences. It is not consequences. It is consequences. Consequences. Tie. So I'm for consequences. Consequences. And your consequences. And your a choice. 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 It is your choice. It is your choice. And your case. It is your own case. It is a party. It is a party or it is a party. And yet it is a party. Yenka party. A party. It is they are having fun at the party. And yet they are having fun at the party. So it is not case, it is not consequences, it is not party. Sanyama when you know here, and it is also not it is not digitalized. It is not digitalization. It is digitalization. And yet digitalization. And then the digital and digital and yet digitalization. 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 And yet digitalization. Yeah, Baumia digitalization says get go. Before Mumbreme. It's Mumbreme. It's say but then some come papa be chori ti butumi nya de kitikiti we na asem fara asem go iti mo mbrɛ me ana have mamu iti say mo beto eye snap nko 50,000 boxes de come papa keke enti entu mutumi nya iti mo ankasa mo ti mo mbrɛ me mo ankasa naturally mo mbrɛ me iti de me ye iti all right mo me kan paragraph 6 yeah that who the incompetent applications. The alien application. Ejuma we bijaya version before. Emi nyanya yo meche papa. Me. Hey. Now mommy anko the the consequences so mommy ankai paragraph 6 that me chiremo. Now paragraph 6 this is what the judge said. Ntimo me pacho yo yetia. Yenya 2027 adibia be yevodo. Now Consequently, since filing of closing addresses is optional and not a function of the rules, that is to say, there is no provision under the rule compelling a lawyer for an accused or prosecution to file an address. But I kind with them you ahana enkene judge no the ruling or true bibi or say and now can bibi or say consequently since filing of closing addresses is optional. What is closing addresses? Let me do a little education here. Now if it's here say a court right now your boy nkuro nyina wie ebi wo hɔ a ansa na judge no edin ruling beba no or say oh both councils obia entro ni opinion and then their friend no addresses and then their friend no your final address that opinion judge no say optional until right now judge no say on the 3rd of July and or the judgment beba no any opinion that is put out by both councils, it is just optional. You can choose not to address. You can choose not to share your opinion on the proceedings, how you saw it, and how you see your client's fate. It is optional. It does not really affect judgment. It is judge and cannot see. And let me read this again. A very important thing maybe I say because right now no the whole thing has become say Appiah Kubi say omuwo address be also address the court no even though the judge is writing her final judgment the address no judge a ruling say the address is optional. Sa address na either the prosecution or the defense counsel will write to the judge they are optional. Technically, they are opinions of both counsel. So, a counsel can choose not to address. So, factually, it does not affect the case, the final judgment, because the judge is looking at what is in front of her, not an opinion. The judge is basing her judgment on facts, and facts are what was provided during the cross-examination, the proceedings from the prosecution and the accused. At this point, the judge is basing his judgment on the facts that were provided. But if the prosecution counsel or the accused counsel decide to address, that is optional and also an opinion of the counsel. It is an obi catcher will say, Appiah Kubi, I will say or address it. Judge no the judgment. The address is optional. Embrabie nuwa. Just address no chinchini and chin. And no never determine or never decide the case. No. You can choose to go through the whole proceedings and decide, say, Mr. Judge, thank you. I don't want to address. I don't want to have my opinion on the whole thing. Write your judgment. A optional. But Appiah Kubi the MP before the creativity to Ghana for him say that address plays a very vital role in the judgment. It doesn't. Now, or say consequently, since filing of closing addresses is optional and not a function of the rules, Yes, a court. You can choose to do it, you can choose to ignore, because it does not affect the matter with evidence. It does not. It's just an opinion. It functions of the rules. That is to say, there is no provision under the rules compelling a lawyer for an accused or prosecution to file an address. Now, Okuren must say, addresses are optional statement made by lawyers to articulate on the merits or demerits on a case one way or the other. Or say, the thing we call addresses are optional statements made by lawyers to articulate on the merit or demerits on a case one way or the other. So basically, your lawyer can choose to address. It is the opinion of your lawyer, because during the address, the lawyer is trying to share his opinion on the whole process. The address does not affect the evidence which was put before the judge. If Appiah Kubi decides today not to be the lawyer of Chairman Wontumi, not Chairman Wontumi a new lawyer, and the new lawyer will come in and share an opinion through an address, but the new lawyer cannot affect the facts or evidence the judge is basing her judgment on. Do you understand? Because you need to understand and say the judge is already writing his judgment. Now, if Appiah Kubi say because he has not addressed the court should stop, no, because it is optional. Now, if Atachia is stepping in for Appiah Kubi, Atachia can address, and the address is optional. So Atachia cannot halt the judgment the judge is writing, because the addresses cannot affect evidence. Evidence sits on its own. The judge is basing his judgment on the evidence. Addresses are opinions. So Atachia, who is now the new lawyer of Chairman Wontumi, can choose not to address, and he can also choose to address. But the issue is, the bottom line is, he chooses to address. Technically, he will share his opinion on the whole proceedings. And if he wants an opinion on proceedings, he can ask Appiah Kubi. Appiah Kubi can give him all that happened in court. Appiah Kubi can share with him all the proceedings, how evidence were tendered in. Appiah Kubi has all the evidence. So Atachia has work to do. He can go to Appiah Kubi and take all documentations, read and share his opinion. But he needs to understand, his opinion cannot affect the evidence that has been tendered in, the evidence that the judge is basing his judgment on. Now we'll read the last part of the judge's statement. Now I'll say, the court would by this extend the time of filing written addresses from the 17th of June 2026 to the 24th of June 2026. Now, judge say, the address, the opinions, because Appiah Kubi, I withdraw the services from Chairman Wontumi, nanka was say written address on the 17th of June, we nanka was say ready. But judge say, because Appiah Kubi is withdrawing his services, Oma akwesi 24th, meaning it is still within the judgment date. Why? Because addresses are just opinions, meaning Atachia still can address through written opinions, address by writing to the court, share his opinion. So Atachia Ochina, what he can do is say, Obetuma ko Appiah Kubi will say, documents are share the court in a former men share. Now, me share proceedings and I'm share my opinion. They are still within the 3rd of July, meaning the judgment is still valid. The strategy of Appiah Kubi and Atachia is to delay the case. But the judge said, if even a person or a considerator, nanka on the 17th, obi ani obetumi submit ne written addresses. But I see, because of what Appiah Kubi is saying, say a new lawyer has come out, the lawyer can still share his opinion.